You know, in India's justice system, a crime isn't just a single event. It's a story. It has a beginning, a middle, and an end. So today, we're going to break down that story into 3 crucial acts. We'll look at the key legal rules that shape everything, from the moment a crime is committed all the way to the final verdict in court.
So just picture this for a second. A crime happens, and you've got 3 suspects. But were they all really in on it together? Maybe one person did the actual deed, and the others just happened to be there. I mean, how does the law even begin to untangle something that messy? Well, it turns out it has a very specific set of tools to get to the bottom of it.
We're going to follow that trail from start to finish. First, we'll start right at the crime scene to see how the law looks at a group of people. Then, we'll jump into the investigation, where just one tiny clue can change absolutely everything. And finally, we'll step into the courtroom for that one critical moment when the accused gets to speak directly to the judge. This is basically the anatomy of a criminal case in India.
Okay, so our story starts with the act itself. When you've got multiple people involved in a crime, the very first question is always, were they a team? And that brings us to a really foundational idea in the Indian Penal Code, Section 34, which is all about something called common intention.
So what is common intention? Well, Section 34 basically says that if a group of people share a plan and then they commit a crime to carry out that plan, the law doesn't really care who landed the final punch or who drove the car. Every single person who is in on that plan is held 100% responsible for the outcome. It's a really powerful form of collective guilt. Now, for a court to actually apply this rule, the prosecution has to prove 3 key things. First, there has to be a meeting of minds, right? A shared plan. Second, each person had to have participated somehow. Maybe they were the lookout, or they drove the getaway car, or they were right there in the middle of it. And third, the crime that happened has to be a direct result of that shared plan.
And here's where it gets really interesting. You've got to see the difference between Section 34 and a similar rule, Section 149. Section 34 needs that proven, prearranged plan, that real meeting of minds. But Section 149? That applies to unlawful assemblies, which is 5 or more people. In that case, just being a member of the group with a shared illegal goal can be enough to make you responsible. So, here's the key takeaway. Section 34 is about a shared mind, while Section 149 is more about a shared group objective.
And this isn't just some dusty legal theory. The courts have been shaping this idea for decades. A landmark case, Mabu Shah, established that common intention really does mean there was a prearranged plan. But, and this is important, later judgments made it clear that this plan doesn't have to be some elaborate scheme hatched weeks in advance. It can literally form in an instant, right there on the spot, seconds before the crime is committed.
All right, let's move to our second act. So crime happened, a group was involved, now the police are investigating. They have a suspect in custody, and that suspect starts talking. This leads us straight to the second pillar of our story, Section 27 of the Evidence Act. This governs how a very, very specific kind of clue can be used in court. Okay, so as a general rule, a confession made to a police officer is completely inadmissible in court. It's a vital safeguard against coercion. But, and this is a huge but, Section 27 carves out this very narrow and often pretty controversial exception. It says that if an accused person gives information that leads the police to discover a new fact, like say a hidden weapon, then the part of their statement that led directly to that discovery can be proven in court. It's a real high-stakes tightrope walk.
And this slide just illustrates it perfectly. Let's say an accused says, "I killed him and hid the knife under the bridge where you can find it." The confession part, "I killed him," is totally out. It's inadmissible. But the part that leads to the discovery, "under the bridge where you can find it," that is admissible. Why? Because it's confirmed by the police actually finding the knife there. But the law puts up some really high walls around this exception, and for very good reason. As you can see, a bunch of strict conditions have to be met. The information has to come from an accused person who is already in police custody, and this is critical, the information has to lead to a fact the police didn't already know. And finally, that discovery has to be a direct result of what the accused said. It's a very high bar to clear, and it's all designed to prevent evidence from being planted.
And to stop any misuse of this powerful tool, there are strict procedures. The police are supposed to record the statement word for word, bring in independent witnesses to watch the recovery, document the whole scene with sketches and photos, and then seal the evidence to maintain what's called the chain of custody. Every single step is there to make sure the discovery is legit.
We are now entering the final act. The crime's been connected to a group, a key piece of evidence is in, the case is going to trial. And here we meet our third crucial rule, Section 313 of the Code of Criminal Procedure. This is the moment the accused gets to address the court directly.
So where does this fit in? If you look at this timeline, you can see it happens right after the prosecution has presented all of its evidence against the accused, but just before the defense gets to start its case. The court basically hits pause. This is the moment for the Section 313 examination.
The entire purpose of the stage is just one word: fairness. It's based on an old legal principle that just means let the other side be heard. It's not a chance for the prosecution to dig for new evidence. No, it's a required conversation where the judge lays out every single piece of incriminating evidence and simply asks the accused for their side of the story.
Now, this is a truly unique moment, and it comes with a powerful set of protections. The accused is not under oath, so they can't be charged with perjury for what they say. The prosecutor has to be totally silent, no cross-examination allowed. The accused also has the right to say nothing at all. And maybe most importantly, this is a direct person-to-person conversation between the judge and the accused, not through their lawyer. It's an incredible shield.
And make no mistake, the courts are dead serious about getting this right. In the landmark case of Ajay Singh, the Supreme Court made it crystal clear. This is not just a formality. A judge can't just ask a vague question like, "So, what do you have to say about all this?" No. They have to go through the evidence, piece by painstaking piece, and put every single incriminating detail to the accused for their explanation. It's all about being precise and totally fair.
So, we've walked through the 3 acts of our legal story: figuring out collective guilt, uncovering a key clue, and hearing from the accused. But how do these 3 distinct laws actually work together? How do they come together to balance the scales of justice?
This table sums it all up beautifully. Section 34 figures out who's responsible by looking for that meeting of minds. Section 27 lets crucial evidence in, but only the part that's verified by a discovery. And Section 313 makes sure the accused gets a protected personal chance to respond to all of that evidence. Each law has a purpose, and each has a built-in safeguard.
When you put it all together, what you see is a system that's designed to build a logical bridge from the crime to the person responsible. It creates a framework that holds groups accountable, lets police use verified evidence, and at the end of the day, guarantees that the accused's own voice is heard before any judgment is made.
Which brings us to the ultimate question, doesn't it? We've seen this intricate system of rules and safeguards, this delicate dance between the state and the individual. So, does all this complexity truly create a fair fight? Or can it sometimes become a confusing legal maze, especially for the vulnerable? Does it really balance the scales, or does the complexity itself sometimes tip them one way or the other? Well, that's the ongoing debate at the very heart of the search for justice.